Good afternoon, everyone.
Your Honor.
All right, I see Miss Falk. Who else do you have with you, Miss Falk, or have they let you go solo? No. There we go, Miss Duncan.
We have Miss Duncan and Miss Sowery, Your Honor.
Okay, good. All right. And I have PD Larry Silverman. There you go. And who
Hi.
else? Oh, Miss
Can you
Kim.
hear me?
Yes. Just doing my little roll call, make sure I have all of my colleagues here. All right, we'll get ready and get started now. Ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have been recently arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused these cases of the offenses brought against them, and the cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge. So we're going to address several matters, if appropriate, which include bond, possible arraignment, or a consideration of a possible plea offer if one has been made by the state at this juncture. I'll also be providing you with the reset date for arraignment or SAP. What is that reset date?
Judge 8/11.
Whew, okay, it's already August. Okay, 8/11. Gotcha. Thank you. And so that will be the reset date for those who don't bond out. Also going to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. And govern yourselves accordingly. The defendants here, you have a right to remain silent. Anything that you say about the facts and occurrences of your case can and will be used against you at a later date. So govern yourselves accordingly and listen to your attorney. Right, who do we have first, Deputy?
Good afternoon, Your Honor. One quick question. We ordered a Spanish interpreter.
Okay,
Is anyone available today?
I thought we were gonna have one. Mr. Jordan said that he knew we had, I think 2 cases that needed an interpreter.
That is correct. I don't know if anyone answered that request.
Yeah, Mr. Jordan.
Judge, he stepped away. He did put in for the request, but I'm not sure of the outcome.
Okay, let's see, maybe they're gonna get on in a few minutes or so. We'll give them a second, but Mr. Jordan did tell me that as well. So we'll see when he comes back if he was able to reach anyone.
Okay, so we're gonna go with position number 12, Mr. Keelan Smith.
Okay. All right, this is case number 22 CR 004775G. Keelan Smith, you're charged with 1 count of criminal trespass. The offense date is July 21st, 2022. Pre-trial, do you have anything?
This is 8th arrest. Last was 2019 probation violation. That was out of Fayette County. Speeding, 2018 parole violation. 2017 suspended license NOLO. Burglary first degree conviction from 2013 out of Lamar County. 2012 probation, theft by receiving, suspended license, parole violation. Suspended license from 2012. That's it. You get my email?
I did, thank you. Oh, I did.
Okay.
Okay, appreciate it. All right, Ms. Duncan?
Good afternoon, Your Honor. This incident occurred yesterday at the 12
Centennial Park condos located at 400 West Peachtree Street in Atlanta and Fulton County. In this incident, Your Honor, the defendant identified in this case as Keelan Smith was on the property of these condos after being previously warned not to return to the property by the concierge. And when officers arrived yesterday, he was on the property refusing to leave. He refused to leave so much so that he did not leave at the officer's request, came back and slept outside. The state has a concern about this defendant being a flight risk, Your Honor. He has several probation violation convictions from 2019, as well as a parole violation arrest from 2018. Given those factors, Your Honor, and the incidences alleged, we're going to request a $500 surety in this case, a stay away from the incident location, no alcohol, drugs, or weapons, and no further violations of Georgia law. Nothing further from the state.
All right. Let's see, Ms. Kim, is this your case?
Yes, Mr.
Okay.
Smith is actually 24 years old, and he has been here, actually 29 years old. I was wrong with my math. He has been here in Georgia all his life, 29 years, and he does not have a job at this point. He was laid off about a week ago, and right now he is trying to set up his own self-employment company to produce some music. He graduated from high school, and he does have certificate of HR, human resource management from college experience. And at this point, my client says that he was simply resting at that location, 12 Centennial Park condo. And he does not understand why it has to be a criminal trespass when all he did was just resting, and nobody gave him previous warning or formal warning before he was arrested. So we would like to request for signature on bond recommended by pretrial as a signature on bond from jail. So please let him go home, and he does need some social worker services. And I will make a recommendation for that one. Thank you.
And if I may correct the record, Your Honor, my apologies. There is a preset $2,500 surety bond on this case, and the person who indicated to officers and that officer acknowledged with the previous criminal trespass was John K. Williams, the concierge. Nothing further from the state.
All right, I'm going to order a $2,500 signature bond through the jail. I'm going to order a stay away. Mr. Smith, you need to stay away from the 400 West Peachtree Street, the 12 Centennial Park condos. Do not go by there. Do not rest there. Do not even go near there, so that you will not be arrested again. I'm going to also order no drugs, alcohol, or weapons while on bond, except for any prescriptions that you may have. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Ask a question.
The only reason that
Mr. Smith, you have a signature on bond. Judge ruled on your favor, so please do not mention anything. You have a right to remain silent.
Social Security Administration is near there, so I was
Please, you have a right to remain silent. I'll call you.
Now, you can go to businesses and such as the Social Security Administration, but it should not cause you to have to be in the condo area. I don't think it's inside of that building or on that property. Even if it's next door, it's not that property. So make sure that, you know, when I say don't go there, I mean specifically there. If you're walking down the street, be on the other side of the street and keep going. Okay,
Yes, Your Honor.
all right.
Thank you.
Next, we have positions 9 and position 10. Mr. Mahan, Jarvis Mahan.
Okay. This is position number 9, 22 CR 004768G. Jarvis Mahan, you're charged with 1 count of simple battery, family violence. The offense date is April 28th, 2022. We have a second case, 22 CR 004770G. Again, a 1 count of simple battery, family violence, and that offense date is June 22nd, 2022. Are they different victims?
No, Your Honor, they're the same.
Same victim, okay. All right, go ahead and, after pretrial, present for both. And pretrial, do we have anything?
Yeah, I gotta get his history. My coworker has it. He went to felony earlier. So
Oh,
I gotta
okay.
get it. Unless the state got it. I'll be back.
okay.
The state, would you like me to
Go
tell you what
ahead.
I have?
Yes,
This defendant has 21 cycles. He's a single state offender. He is a convicted felon, Your Honor. This defendant has an aggravated battery guilty conviction from 2016. He has a guilty theft by receiving stolen property, willful obstruction, and criminal damage to property from 2016. This defendant also has another simple battery family violence conviction against this same victim from March of 2022. And another simple battery family violence conviction against the same victim from March of 2022. On both of those, he received a total of a $5,000 good bond, $2,500 apiece. This defendant additionally has a previous battery family violence conviction against this same victim where he went to jury trial and was convicted guilty. And under the magistrate court number for that case, Your Honor, he received an $8,000 cash only bond. It is the same victim. He has an additional battery family violence case where he pled NOLO in 2014. That was a different victim. There's another battery conviction from 2018, different victims, Your Honor. He has an additional battery conviction from 2018 as well. And he has 6 counts of probation violation in which he was found guilty in 2019 and has 5 counts from 2018. This defendant does have 2 open cases. One is a felony battery family violence against the same victim. That case number is 22 CP 210873. And he has an open possession of cocaine and marijuana less than 1 ounce, 22 CP 07273, Your Honor. So that is the gist of this defendant's history. Would you like me to continue with the recitation of the case?
no, you can go ahead and present on the cases. That's good on the history. Thank you.
He
Okay,
got no bond and felony.
No bond, okay.
Yeah.
okay. In the first case, Your Honor, the incident occurred on position 9. The incident occurred on February 28th, 2022. The incident location is listed at 494 Ponce de Leon Avenue. In this incident, the defendant is alleged to have spit in the face of the victim in this case, Ms. Jasmine Bryant, who is a parent of the same child as the defendant. They were standing outside at the bus stop waiting for the bus when they got into an altercation. And because of the altercation, he spit in her face. Given that this defendant has several previous violence and family violence convictions against this defendant, we have a supreme concern for risk of reoffending as well as a flight risk due to the previous probation violations in his history. So that's the facts for the first case. And in that case, Your Honor, the state is going to be requesting a $7,500 cash only bond, no further contact with the victim, Jasmine Bryant. Because as stated previously, Your Honor, he was previously convicted of battery family violence in 2019. And in that order, as well as the other simple batteries, he was told to have no further contact with this victim. They now have a child. So the state is going to request a third party contact, a stay away from the victim in this case, a family violence intervention program, no alcohol, drugs, or weapons, and no further violations of Georgia law. Moving on to position 10, Your Honor. This incident occurred on June 22nd, 2022 at the address of 443 Ponce de Leon Avenue. I think it is notable for the record, Your Honor, that this defendant has current stayaways related to bond orders from this address. This is the victim, Jasmine Bryant's address. And in this incident, Your Honor, the victim, Ms. Bryant, called the police to report that she had been assaulted by the father of her child. because he wanted to have sexual intercourse with her, but she refused because they had just had a child. And she said that he became angry and he pushed her down, causing her to fall onto the ground. Given the facts and circumstances alleged, given that this is the 5th violent encounter that this couple has had, we're concerned about the risk of reoffense given the history stated above, as well as intimidation of the witness, Your Honor, because I also thought that it was notable that the court should know that this defendant has previously threatened to kill this victim if she ever made him leave her. So we're concerned about the safety of this victim and the intimidation factor that's present here, along with the cycles of domestic violence. And we're concerned about the flight risk. So for those reasons, in this case, we're going to request a $7,500 cash only bond, no further contact with Jasmine Bryant, third-party child contacts, stay away from the incident location of 443 Ponce de Leon Avenue, a family violence intervention program, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state. And it's my understanding that the victim may be on the line. So if Your Honor would like to sound for her.
Okay, is Jasmine Bryant on the line? Jasmine Bryant? You don't see her, do you, Ms. Middlebrooks? All right, Jasmine Bryant. Don't think she's on.
No, Judge, and it's Miss Grace today, sorry.
Oh, I'm sorry, Miss Grace. I'm
No
sorry.
problem.
I apologize. Hold on 1 second. I'm sorry.
Hey, Mr. Lynch, I sent you a message in the chat per your,
Yes.
per your client.
All right, I'm sorry. I heard someone talking, so we don't have the victim on the line. Is that correct?
My understanding, no, we don't.
All right. My ruling in the first case, the one ending in 768G, I will grant.
Your Honor, Judge Mincy.
sorry, I have
apologize. I hate to
not,
interrupt defense.
I have not let the defense go.
No.
And I apologize. That's what I get. I had something I had to look at real quick, so I apologize. Whose case is this, Ms. Kim or?
Your Honor, Owen Lynch, one of the conflict defenders, been appointed previously to represent Mr. Mahan.
Oh, I'm sorry. I did not. I thought you were just private counsel for someone, but I apologize, Mr. Lynch. I haven't met you before.
No problem, Your Honor. May I proceed?
Yes, you may. And again, I apologize.
Your Honor, my client is 37 years old. He has obtained his GED to complete up to the 11th grade and completed his GED thereafter. My understanding is that for the last 6 months, he has worked at the Popeyes on Boulevard as a manager. He does have a newborn child, as mentioned, with the alleged victim in this case. What we're requesting at this time is a very reasonable bond in his case, so that he can hopefully, when he's able to get released, have a chance to get back to work. That's what we're asking for at this time, Your Honor.
And this is a newborn child?
3 months is my understanding.
Yes.
All right, and the parties are not married?
No, Your Honor, they're not married.
All right, what I'm going to do on this first case ending in 768G is a $7,500 cash bond, cash only bond for $7,500. I'm going to order no further contact with the victim, Jasmine Bryant. I'm going to order no drugs, alcohol, or weapons while on bond. And I'm a little conflicted about ordering that he can see this child by a third party. I think with all of the history that I'm hearing, I'm not going to order that or allow that at this time. Because I just don't think that he needs to see the child at this point with all of the prior cases and the pending and everything else is just too much. He's got to understand that that's not the way to communicate with your child's mother. That's not the way to treat her. And I understand there are allegations, but there's enough history here to make me very concerned about him going around her as well as the child. So I'm not going to order any visitation or allow any visitation. The victim doesn't have to either, considering the fear that she may be in as well. That's for, is there anything else I need to take up on the first case?
Would there be a stay away, Your Honor?
Yeah, and stay away from the incident location, which again is the address for the victim. And I believe that's the Ponce de Leon address.
Yes, Your Honor.
All right. So stay away and no further contact with her or the child at this point.
And would you be imposing, my apologies, a family violence intervention program?
Well, I don't know if he's going to be out to do that. I will go ahead and entertain that. Maybe it'll help him. So I'll go ahead and impose a FVIP. Got to get it together. All right, on the second case ending in 4770G, I will enter the $7,500 cash only bond. Same conditions, no further contact with Jasmine Bryant, the victim in this case. Stay away from the 443 Ponce de Leon. No drugs, alcohol, or weapons while on bond. And I'm not going to order any third-party visitation, none. And I think that is it. Is there anything else when you take up, Mr. Lynch or Ms. Duncan?
Nothing further from the state.
Nothing further from the defense, Your Honor. Thank you very much.
All right, thank you. Is that the only case you have, Mr. Lynch?
That is the only case today. Thank you very much. May I be
All
excused?
right. Yes, you may be excused. Good to meet you.
Nice to meet you as well, Your Honor.
Mm-hmm.
Your Honor, next we have Mr. Patton, position number 11.
This is case number 22 CR 004772C. And that's, I think that's Moncrief Patton. 1 count of criminal trespass, The offense date is July 21st, 2022, pretrial.
11 total. Last arrest was back in May, sale of marijuana. Has an open case in Superior Court, 20 CP 193-466. Possession of marijuana, possession of a firearm by convicted felon, suspended registration. Got a possession of marijuana with intent, pedestrian and roadway open, 22 CP 209-220. On probation in Muskogee County for burglary, smash and grab. 2018, they gave him 4 years to serve, 7 years probation. 2017 probation violation, 2016 probation. 2015 probation, came off of entering auto, criminal damage to property, 2nd degree, theft by taking. That's it.
All right. Ms. Duncan?
Yes, Your Honor. This incident occurred at the Family Food Mart on 12 Atlanta Avenue. In this incident, the defendant is alleged to have been exiting this location when Officer Woods was entering the location while doing a patrol in the area. The officer noted that this defendant had been previously criminally trespassed from this location for selling drugs outside of it on May 20th, 2022. He was noted at that time to not return, and he was also notified that the store owner did not want him there anymore after the May 20th, 2022 incident. When the officer noticed the defendant coming out of the store, he was arrested for criminal trespass, Your Honor. The state in this instance has a concern about the risk of reoffense because, as noted, this defendant was previously notified not to return, and he did so anyway. We also have a concern about flight risk here, given the multiple probation violations. Given the facts and circumstances alleged and the all the factors present in the case, the state is going to request a $2,500 surety bond, a stay away from the incident location, no alcohol, drugs, or weapons, and no further violations of Georgia law. Nothing further from the state.
Okay. Ms. Kim?
Yes, Mr. Patton is 24 years old, and he believes that on that day, actually, store owner allowed him to come in to the store. He feels like he was lured into be arrested, and he didn't get any previous warning. That's what he tells me. And he has been here in Georgia for all his life. He does not have any children, and yet he resides with his mother. He has he's gainfully employed at DHL. He does packaging. He has been employed for the last 3 months. He has a GED, and we would like to request for a signature on bond. And yet, because of the previous history of probation violation, if Your Honor is not inclined to give him a signature on bond, we would like to request for the maximum $500, Your Honor.
And Your Honor, if I may, on that May 20th, 2022 incident, there was an Officer C. Smith and an Officer J. Valencia who criminally trespassed this defendant. And even if the defendant did not feel like he was lured in, it's his responsibility not to go back. And he was aware that he shouldn't have gone back. Nothing further from the state.
Okay. I'm going to order the $2,500 surety bond, and give me the stay away address again.
The stairway address is 12 Atlanta Avenue, the Family Food Mart.
Okay. So there is, again, the $2,500 surety bond, stay away from the 12 Atlanta Avenue. No drugs, alcohol, or weapons while on bond. Anything else?
Nothing further.
All right, thank you.
Your Honor, a Spanish interpreter is ready, so maybe either I or Mr. Lawrence can have a breakout room to interpret.
Okay,
Your Honor, we're about to set that up. I have Officer Matthews going to courtroom 1
okay,
with both clients.
Okay,
Who would like to speak first, Mr. Silverman or Ms. Kim?
I'll be happy to speak first.
Okay,
Which are the two cases?
and
We
which
have
one's going first?
Actually, position number 3 is PD Larry Silverman, and mine is position 6, Garcia Reyes.
Okay, and which one do you have first, Deputy?
so we could put Garcia Reyes and Ms. Kim.
Okay, thank you.
Do that one first,
And I'll do all Mr. Silverman's cases.
second, so they can go into a breakout after them. Okay,
That's correct, yes.
okay, that sounds good.
So that'll be courtroom 1 and Ms. Kim going into a breakout. We're ready.
All right. Well, I think, are they going into a breakout?
Yes, it's gonna be Ms. Kim in courtroom 1 in the breakout.
And then you can only do one breakout at a time, right?
He'll go later after Ms. Kim.
Okay. All
But
right.
I have position number 1, which is Mr. Silverman's client, Mr. Anderson.
Got you. Sorry, I was a little confused. It's Friday.
It's okay.
It's been a long week. All right, there we go. Position 1, which is Kelvin Anderson, case number 22CR004773H. You're charged with 1 count of willful obstruction of a law enforcement officer, 2nd count of giving false information to law enforcement officer, and a 3rd count of the same, giving false information. The offense date is July 21st, 2022. Pre-trial, do you have anything?
I count about 15 total.
Okay.
Between Connecticut, Massachusetts, and one of them other states. Hold on. Vermont. It was one in Vermont. I got a 2020 Vermont vehicle operation without owner consent / aggravated. That appears to be open. This is first Georgia arrest. So as far as Massachusetts, seen 11 cycles, 12. April 2021, cocaine trafficking. 2019, I see a robbery. Assault and battery on a family member. Those charges were dismissed. I see a 2008 armed robbery. The disposition says 8 to 10 years. So I'm assuming there was a conviction. 2006, distribute cocaine. 2005, possession of ammo without ID. Distributing, theft by receiving. What else? Oh, and the Connecticut arrest was 2003. That's all.
Okay, so that's good. Thank you, Ms. Sorry.
Yes, Your Honor, and I'm sorry, pre-trial, I just want to make sure that's for Kelvin Anderson, position 1.
Yeah. You don't have anything?
I have the first Georgia.
That's all you got?
Yes.
Yeah, so I had to do a little digging. So I waited. They ran the history before the FBI, before he got fingerprinted. So that's why you only have 1. So once his fingerprint hit, that's when the FBI number popped up in Odyssey.
Gotcha. Thank you
So
so
I
much.
had that as well, though.
Okay. Your Honor,
Thank you for clarifying that.
thank you. This incident took place at Piedmont Park, located at 1073 Piedmont Avenue Northeast in Atlanta. An officer was patrolling the park when he saw the defendant and another subject in the park after the permitted hours. When the officer asked the defendant for his ID, he said he didn't have one and gave the name Miles Fields and date of birth 9/18/1998, which were false identifying information. When the officer asked for other easily known information, the defendant stumbled over the answers. The officer then returned to his vehicle to run the information, and the defendant fled on foot. Officers gave chase and ended up having to deploy his taser in order to stop the defendant. The defendant was immobilized for a moment, but then he attempted to flee again, which led to him being tased again. Your Honor, the state's recommendation in this case is a $1,000 surety bond. That's $500 on the obstruction and $250 on the remaining charges, with conditions of no drugs, alcohol, or weapons, as well as a stay away from the incident location. Nothing further.
All right. Mr. Silverman?
Good afternoon. Can you hear me, Your Honor?
Yes, I can.
Okay, I just connected some new headphones, so I wasn't sure. It's nice to meet you. I've never been in your
Yes,
court
you
before.
too. Nice to meet you.
Mr. Anderson, yes, as you heard, this is just a matter of being in the park after hours. This, what was essentially a city ordinance, has now been accused into 3 different offenses or 3 separate charges. Mr. Anderson is relatively new to the area. He's 36 years old. He does come from the Northeast, and he's come to Atlanta to step up to the plate and take care of his son and the mother of his child. Based on the type of the offense, the nature of the offense, and that was just being in the park at night, pretrial has recommended a SOB, and I would ask the court to impose that.
So let me chime in real quick. The bond assessment that was sent out earlier was based on him not having a history because they didn't have the correct history, just so you know.
Okay.
Yeah. So it's just it's up to you.
Okay.
And Your Honor, we will ask you to take notice of the history we heard today.
All right.
Well, and I'd ask the court not to disregard that because he doesn't have any outstanding holds or warrants. This is an entirely separate matter. The nature of the charge is not even related to any prior act, and it was just a city ordinance. So I would ask the court just to give him the signature on bond. And I'm also going to object to the stay away order. I mean, I think it would be appropriate for there be an order for no further violations of Georgia law, but basically there's no reason to keep him out of Piedmont Park.
And Your Honor, the reason for the stay away is due to him not following he was in the park after hours, so he's not following the ordinance. So that was the reason for the stay away, but we will defer to your ruling.
Okay.
Yeah.
All right. I'm going to,
Hello?
who's talking that should not be talking? Is that you, Mr. Anderson?
I was raising my hand. I don't even know what talking.
Nope, you have an attorney who's representing you well. My instructions were to defer to your attorney so that you don't say something against your interest. I'm getting ready to give my ruling. All right, I'm going to order the $1,000 surety bond. I will not order the stay away from the park, but obviously adhere to the hours, or else you'll end up right back here in jail. And that breakdown will be 500 on the obstruction, 250 on each of the giving false names. So that totals 1,000 surety bond, and no drugs, alcohol, or weapons while on bond. And I think that will conclude it. Anything else, counsel?
Nothing further from the state, Your Honor.
All right, thank you.
And nothing further from the defense. Thank you.
Mhm.
Excuse me, Your Honor, how much was that bond amount? Was it 1,000?
A 1,000 total, yes. 500 on the obstruction, 250 on each of the false names.
Okay, thank you.
Uh-huh.
You good. I told you. Next, we have position number 2, Mr. Denzel Bay. What's your mask on, Mr. Bay?
And Your Honor, I'm asking for a breakout for this position.
Okay. Mr. Jordan. See if he's back. Ms. Falk, Ms. Sorry. Is this your case, Mr. Silverman?
It is, Your Honor. I have a few more, so I don't know if you want to send me into a breakout room now or continue going through the calendar.
It's not too bad. We'll go ahead and break out real quick while we're here.
Your Honor, there also are, we do have a new attorney that I would like to attend if he is sitting in. Mr. Evan Dudley is one of our new ASGs, and I would like him to be in attendance.
Who's your client, Mr. Smith? Oh, Eric first. Never mind.
We are back with position number 2, Denzel Bay. Case number 22 CR 004747E. Do I have any persons on the Zoom with this case? Anyone connected with this case at all? All right.
Your Honor, this is my case. This is the one we just met about in the breakout room.
Right. I was just making sure that there were no victims or anyone else on the Zoom.
I
Some-
don't
I
I
can-
don't believe the victims are on the line, Your Honor.
Okay, thank you. All right, we have discussed this case, Mr. Bay, in the breakout room or in caucus, and I'm going to give you my ruling. Okay,
Yes.
can you hear me?
Oh, yes, I can.
Okay, so what I'm going to do is I'm going to enter a $5,000 surety bond, $2,500 on each charge for a total of $5,000 surety bond. I'm going to order that you have no further violent contact with the victims in this case, which I understand to be your parents, Eli Bay and Denise Mason. So you to have no further violent contact with them. But I'm also going to do this a little different. And I'm going to order a 10-day stay away from the incident location to be your home, 1604 Summit Springs Drive in Atlanta. I am concerned about a cooling down period and making sure that everybody will be able to eventually live and get along. So for 10 days, I'm going to order that you stay away from the home. As long as you've had no other incidents in that 10-day period, then you can return. No further violent contact with your parents while you're on bond. No drugs, alcohol, or weapons except for those prescriptions that are administered to you that were ordered and given to you by a physician. I'm going to also order that you stay on the medication that you've been prescribed and that you continue or recommence seeing your physician and getting the assistance that you need. So that's why I say recommence or start over or continue with your treatment and the medication that has been prescribed to you. Otherwise, no other drugs, alcohol, or weapons. I'm going to order the 1-day anger awareness course for you. And a behavioral eval as well. All right.
Evaluation,
I'm sorry.
behavior evaluation,
Yes.
do that have something to do with a psychiatrist?
Mr. Silverman, I don't know if it's a psychiatrist or not. Or is it
Our-
more psychologist?
Our social worker services will visit and they conduct those tests.
Okay, that would be a social worker.
Thank you.
Yeah, they also may be able to help you determine where you can stay for those 10 days that you cannot go home, okay?
And,
All right, that will conclude my ruling.
all right.
Thank you, Your Honor.
Thank you.
Your Honor, can we put the Spanish interpreter and Mr. Silverman
Yes,
in the breakout room with courtroom 1? And then I can go to the private attorney's case and also
Okay.
Ms. Kim's case.
okay. You're doing good with your logistics.
I'm trying. And I'm gonna have Mr. Eric Ferguson, position 5.
Okay. This is 22 CR 004776F, Eric Ferguson. You're charged with 1 count of fair evasion, willful obstruction of the law enforcement officers, and a second count of willful obstruction of law enforcement officers. The offense date is actually it's 3 charges, I'm sorry. And the offense date is July 21st, 2022. Pre-trial.
His 9th arrest. Last arrest was July 2021. Ag battery, kidnapping, ag stalking. That's open in the cab. On probation in the cab for simple battery, family violence. February, they gave him 24 months. He is wanted out of DeKalb County for burglary 1st degree. So that's what the hold is for. Simple battery, disorderly conduct conviction. That's the 2019 one. 2018 obstruction, reckless conduct, those were dismissed. 2017 marijuana. 2016 ag assault, amended to battery conviction. The first 3 cycles are juvie, so he got 6 adult arrests. That's it.
All right. Ms. Falk? No? Yes?
Yes, Your Honor, it is me. Thank you. So this occurred at 377 Decatur Street, which is our King Memorial Station, MARTA, at 10:35 a.m. yesterday. The defendant essentially walked through a closed fare gate. It was witnessed by officers Point du Jour and Bailey, who were in plain clothes. When they approached him and displayed their badges and tried to place him under arrest, the defendant jerked his hand away and began to flee. Currently, the defendant has a $1,500 surety bond. That's $1,000 on the obstruction, $500 on the fare evasion. As pretrial has correctly pointed out, he currently has a foreign hold from DeKalb County in the jail record for that burglary in the 1st degree. He also was released on bond a little less than a year ago on that ag battery, ag stalking, kidnapping case out of DeKalb County, which is still open and has that most recent conviction for disorderly conduct in DeKalb. So our concerns with this case, I mean, realistically, fare evasion, obstruction, not the worst things in the world, but what we're really concerned about is this defendant is 26 years old and he has 9 cycles already, and he's got some pretty heavy hitters. I mean, he is not, playtime is over. He had 3 cycles in juvenile and then proceeds to rack up burglary, ag stalking, kidnapping, ag battery. These are not mild offenses. An ag assault bumped down to battery. So we do have some really serious concerns that he is a high risk of reoffense. He started off in juvenile court, has kind of kept his foot on the gas through the felony division, and now has this warrant out for him in DeKalb and has this case. We are asking for a $2,000 split bond. That's $1,000 on the obstruction, $500 on the fare evasion, and then $500 on the second count of obstruction, which was an add-on because he fled from 2 different officers. So it was done in the alternative. And we're asking that there be a condition not only to stay away from the King Memorial Station at MARTA, no alcohol, drugs, and weapons, but that the defendant can only be released to DeKalb County in order to answer on his hold if he is able to make the bond. Nothing further from the state.
All right. Is that Mr. Smith for the defendant?
It
Scott
is.
Smith? Okay.
Judge, good to see you.
Thank you.
Judge, we're asking for an unsecured judicial release on this case. Putting a good bond on this case serves no purpose, as he's got a hold. He's got bigger fish to fry in DeKalb County. Only people that profit off that are the bonding companies. As you heard, it's a fare evasion case. I haven't seen one of those since I was a solicitor in 2000, but it's good that they're still prosecuting those. I'm glad to hear that. And then the obstruction, obviously, we're going to look into that. It's 2 counts of the same conduct, that is fleeing from the officers, is my understanding, and pulling away from one of the officers. But we'll present a defense on that case. He's currently out on bond on the most serious charges that was read off on his GCIC. He received a $25,000 bond on that case. We were able to post that. And once we get over to DeKalb, we'll deal with those cases over there.
Okay. I think the state was recommending a split bond. And I'm somewhat inclined just to make sure that he understands the seriousness of the road he seems to be going down. Does he work or anything, or what's going on with him at 26?
Yes, Judge. He is employed or has been employed, day laborer type work. He's got the family support. I've been retained on the pendency of his cases in DeKalb County. And he's lived here all of his life. His ties are only to Georgia.
I got 2 jobs now.
What's that, Eric?
I have 2 jobs. That's why I was on MARTA. I do the voter registration job, and MARTA has been helping me. I was getting my Social Security, and I work at Bell Bar Middle Eastern as a dishwasher. MARTA was helping me. It helped me get my social. It helped me get both of those jobs. I just didn't have the money at the time. My check supposed to come on the 28th. MARTA really was helping me get everything that I was getting established to help pay my bonds. I haven't been getting in no trouble in those aggravated assaults when I was self-defense case. That's why I got dropped down the battery. It was a self-defense. I don't cause crimes or do none of that. In those family violence cases with the mother of my children, I got kids on the way now. I was apologizing to them for that. I needed that. I needed MARTA to help me to get to this check in the next couple of days.
Well, I understand that you need MARTA, but there are other means for transportation.
I don't have no major support like that, man. I'm sorry though. I know I was wrong, but I didn't run. MARTA helped me get my temporary social to get those jobs and to get back and forth to work, and I'll be walking.
Okay, I'm going to do the split bond, and on the obstruction, it'll be $1,000 surety. And then on the other two, the other fare evasion and the other obstruction will be 500 SOB through the jail. So technically that's a $2,000. Did I add that right? Yeah, $2,000 split bond, 1,000 surety, and then the 500 on the other obstruction and the fare evasion will be SOB jail. I'm gonna order no drugs, alcohol, or weapons while on bond. I'm torn a little bit about you going back, because even though if you say I don't have the money, you still don't have a right to jump fare or steal it because you don't have the money. Then you've got to either thumb it, get a ride from somebody or an Uber, or do something else and not get into trouble for fare evasion. And I get it, or borrow the money from somebody. And you're saying if you're well, you might already be banned from MARTA.
Your Honor, that's actually what I was going to say.
Yeah,
Whether Your Honor prevents him from going on MARTA or not, MARTA oftentimes issues a stay away from
Right.
MARTA. So
Right.
we actually recommend it because otherwise it gets very confusing when the judge is saying, okay, you can go back on MARTA, but MARTA's issued a suspension and said you absolutely cannot come back here.
Right. And they have the recognition software, so they're going to see you when you come. So unfortunately, I'm going to have to order that you stay away from MARTA while you're on bond, at least that King Memorial Station. And generally, they will say from that station, although again, correct me if I'm wrong, Deputy Falk, they sometimes say all MARTA.
They
I
can
just
do
wish
a
we
broad
knew.
blanket ban, but we are only asking for King MARTA Station at this point.
Okay, but we'll just do that from the King MARTA Station. There's a stay away. I imagine if your attorney checks with them before you go over there or go anywhere near that station, which you should not, to make sure and to see whether there's already a ban there. Mr. Smith, if you could help him out on that.
Yeah.
But I would want you to follow what Marta's doing. So I'm going to do the stay away. And then your attorney can ask for a modification if you find out otherwise. And then again, if you make this bond, you are to obviously be taken straight over to DeKalb County and not hit the street, but to be transferred immediately to DeKalb County if you make this bond. Put that in the order for me, Ms. Grace.
Will do, Judge.
All right, thank you. All right, that should conclude this matter unless council has anything else to take up.
No, thank you, Judge.
All
Thank
right,
you.
thank you.
Thank you so much, Judge.
All right, good luck to you.
Next, we have position number 7, Frederick Hart, position number 7.
This is 22 CR 004771E, Frederick Hart. You're charged with 2 counts of theft by shoplifting, 1 with the offense date of June 30th, 1 with the offense date of June 9th, if that is correct. Pre-trial.
43 total.
Your Honor, hey, son, can you guys speak up a little louder? He's hard of hearing.
Oh, okay. Did you hear what I said, Mr. Hart?
The mic muted.
I was putting the speakers close to him.
Okay. Do I need to repeat what I said, Mr. Hart? Did you hear me?
Yes, ma'am, repeat that.
Okay. This is case number 22 CR 004771E. You're charged with 2 counts of theft by shoplifting, 1 with the offense date of June 30th, 2022, 1 with the offense date of June 9th, 2022. Okay?
Okay.
All right, pre-trial?
43 total. Last arrest was April 5th, shoplifting. He got convictions from 2006, 2008, 2021 for shoplifting. He was arrested 2021 for shoplifting, September. October 2021 shoplifting, August 2021 shoplifting. Yeah, Judge, it's a lot of shoplifting. So I counted 3 convictions so far.
That's fine. All right, go ahead, Ms. Falk.
Your Honor, I want to preface this by saying we held off on transferring this because some of the convictions are out of municipal court, and we just wanted to verify those before transferring it to the DA's office. However, the defendant does have 2 open shoplifting cases. One is 19 CR 002989J. He was actually arrested on a dormant bench warrant on that and is currently in jail on a $1,000 surety bond on that case. The other case is upstairs currently in the DA's office. He was actually arrested for that on the same date yesterday as he was arrested for our cases. I believe that is going to be case number 22. Oh, actually, currently it's not showing a CP number that I have in our jail system. So he does have those cases, and it was in that felony shoplifting case from yesterday that it had his 3 previous, including an Atlanta municipal court conviction, which we just need to verify before we send up this case. So in this case, he had a June 9th and June 30th shoplifting. June 9th at 8:28 a.m. Joseph Hallbeck, who's the manager of Dollar General, located at 2750 Donald Lee Hollowell Parkway, flagged down the officers and stated an unknown male had come into the store concealing in his arms 4 packs of Pampers and left at the location. That was with a value of over $100. On June 30th at 11:30 a.m., the same manager, Mr. Hallbeck, called police again and told him that the same defendant that he had seen on June 9th had come back into the store, stolen 5 packs of Tide Pods with a value of $18.72. At that time, Hallbeck was able to show the officer's surveillance video, which showed the defendant stealing those Tide Pods, and he was able to identify the defendant as Mr. Hart because the defendant had been arrested repeatedly for stealing at the same location, that Dollar General, and had actually gone into the pre-arrest diversion program on one of the previous theft by shopliftings. So as I have stated, this defendant has a number, and as Mr. Howard has stated, this defendant has a number of theft by shoplifting convictions, which would make him eligible for felony treatment if we are able to confirm those shopliftings from the Atlanta Municipal Court. We are asking for a $3,000 surety bond, $1,500 on each charge, for a total of $3,000. A stay away from Dollar General at 2750 Donald Lee Hollowell Parkway Northwest. We are asking for an anti-theft course be applied in this case, and we are asking for no alcohol, drugs, or weapons. That is all from the state.
Yes, Your Honor. Mr. Hart is actually 50 years old, and he was born and raised here in Georgia, and he has no children and no other family members right now to help him out. He has not had a job for the last 4 years, and he is right now homeless, and he was stealing those to exchange for food. And we would like to request for social worker services along with that ADET and behavioral health evaluation test so that he can get appropriate help. And also he cannot even afford $18.72. There's no way he's going to be able to afford, even if the bond is only $1,000, Your Honor. So we would like to request maximum $1,000 surety bond altogether. Thank you.
All right. Ms. Kim, what's his work history?
No work for last 4 years.
Not on disability or anything? No, what he doing for income?
He said that he has some addiction issues, so we are requesting for ADET for him to get a help. He asked for help.
All right, I'm going to order the $3,000 surety bond, $1,500 on each charge. I'm gonna order that he stay away from the Dollar General at 2750 Donald Lee Hollowell Parkway. No drugs, alcohol, or weapons while on bond. Is there anything else we need to take up, counsel?
Nothing further, Your Honor.
All right, thank you.
Well, Your Honor, I think the
I'm sorry.
anti-theft course was addressed, and BHET.
Yeah, the VH, can't get my letter straight. ADET, yes. I won't do the anti-theft course. I'll just do the VH-ADET.
Thank you, Your Honor.
You still gotta go to the court for something else. You still have to go to court for something else. Come on. Yeah, I'll tell you. Here's a. Next, we have position number 8, Mr. Brian Hoyt.
All right, this is 22 CR 004774Y, Brian Hoyt, charged with 1 count of false report of a crime, offense date May 7, 2022, pretrial.
15 total. Last arrest was 2017 probation violation, 2016 probation. He had a possession of amphetamine conviction from 2015. 2015 suspended license NOLO. 2013 simple battery conviction. 2010 probation, not prosecuted. Possession of marijuana and driving without a valid license conviction, 2010. 2009 battery no load. And a 09 FTA that was not prosecuted. That's it.
Okay. Ms. Falk?
Yes, Your Honor. So this started on May 8th, 2021, when the defendant called police out to 3276 Northside Parkway, apartment 3321, in reference to a theft. The defendant initially told officers that his laptop was stolen out of his bedroom, and it was taken at some point when he returned from grocery shopping. The officers noted there was no signs of forced entry into his apartment, and they spoke to witnesses, including the courtesy officer, who alerted the officers to the fact that the defendant had called in issues consistently ranging from harassment to burglaries, which then later proved false. That's going to become important given that on and let me just make sure I have my facts correct. On July 22nd of 2022, June 28th of 2022, the officers then learned that this defendant had pawned his laptop at a pawn shop located at 4230 Buford Highway. He had taken it to Cash America Pawn. The officers went to the pawn shop, pulled the video footage. It showed the defendant selling his laptop. They also had a copy of his Georgia driver's license, just for good measure, that also showed the defendant. And the female pawn shop associate also identified the defendant as the person who was pawning his laptop. As the pretrial has mentioned, this defendant has probation violations spanning from 2009 to 2017. I counted at least 4. He doesn't have any theft history, but what is interesting is he has a pretty extensive drug history, including a conviction in 2016 in Cobb for possession of amphetamine. Currently, the bond is set at a $1,500 surety bond. We are asking that it remain the same, with the conditions that the defendant stay away from Cash America Pawn at 4230 Buford Highway. That is all for the state.
Yes, Your
Okay.
Honor. Mr. Hoyt, this is the one case that pretrial services recommended for unsecured judicial relief through jail. This is simply, it was actually lost, and he says that somebody returned his laptop back to the top of his car roof. So he found it back, and the only thing that he made a mistake was not calling back to let the officers know that this was found again. We would like to request for signature on bond for this one. He has been here in Georgia for 37 years. He was born and raised. All his family members are here in Georgia. He has gainfully employed at Champion Yard Services as an office assistant for the last 2 years. He graduated from high school. He is very settled here in Georgia. He's not going to be a flight risk to anybody. And we would like to request for UJR jail, please.
Your Honor, I do want to correct something, because I believe I said May 7th, 2021. It's May 7th, 2022. I will also say that Mr. Hoyt didn't even have to take the step of calling the police. They actually tried to follow up with him several times by phone, called his mom and got his number, text messaged him. So literally any method of response would have resolved this misunderstanding about where this laptop went.
Okay. I'm going to order the $1,500 surety bond. I'm going to order stay away from the Pawn America 4230 Buford Highway. And then the Northside Parkway address, whose address is that one, the 3276?
That appears to be his resident. I can't ask for a stay away from his own
Right,
residence.
I was
but yeah,
making
that's-
sure because I thought I knew I heard the Pond America, but the first address
Right,
Alright.
the first address
Right.
is his home.
is home, okay. So we're just gonna ask him to stay away from the Pond America, $1,500 surety bond, no drugs, alcohol, or weapons while on bond. And I think that should conclude everything. Anything else?
Oh, Your Honor, thank you.
Okay,
Thank you, Your Honor.
all right.
Next, we have position number 4, Mr. Nick Dominello.
All right, this is 22 CR 004754C. Nick Dominella, you're charged with 2 counts of terroristic threats, both with the offense date of March 21st, 2022. Pre-trial?
6 total. 2018 battery DV conviction. 2012 possession of meth. 2011 got simple battery. 3, 4 counts. 2 counts of battery DV. 2 counts of disorderly conduct. 1 count trespass. 1 count hindering person from making emergency call. All those were DWAP. Before that was a 05 battery dismissed. That's it.
All right, Ms. Sorry.
Yes, Your Honor, this incident took place at 179 Haygood Avenue, Southeast in Atlanta. There was a verbal altercation between the defendant and 2 victims, one named Gary, last name G-A-N-A-H-L. The second first name is Thomas, same last name G-A-N-A-H-L. The defendant then threatened to burn down the victims' homes. The victim stated that the defendant has threatened them on more than one occasion, and these threats were corroborated by 2 witnesses, one named Daryl, D-A-R-Y-L, last name Williams, and the second Andrew Burke, that's B-U-R-K-E. As we've heard from pretrial, this defendant does have violence in his history. He has a battery family violence conviction from 2018. It does not concern either of these victims. However, it is an act of violence. He did have a 2005 battery case that was dismissed and a 2012 battery family violence, simple battery, disorderly conduct, hindering someone calling 911, and criminal trespass that was also dismissed. Your Honor, due to his history, the state is concerned with the risk of reoffending, the risk of intimidating either of the victims or the witnesses, and the fact that he does have a violent charge or conviction on his history. The state's recommendation is a $5,000 surety bond. That's $2,500 on each charge, with conditions of no contact with the victims or the witnesses, 1-day anger awareness, stay away, and no drugs, alcohol, or weapons.
All right, Mr. Silverman.
Silverman, thank you, Your Honor. Mr. Dominella is 44 years old. At the time of this incident, he was residing with some other gentlemen. And yes, there was a verbal argument. And he may have threatened to burn the house down, but he had no present ability or intention to do so. It was just a matter of an argument and exchanging insults. The history that the state cites as the reason for the bond, it sounds to me like everything was dismissed for no profit. So that should not be taken into consideration now. He no longer lives at the residence on Haygood with these other gentlemen. He now lives in Atlanta. He's been there 6 or 7 months. One of the witnesses, sorry, I forgot which one, he's actually still very good friends with, and they they have ongoing contact. The pretrial has recommended that unsecured judicial release, and given the nature of the offense, I think that's certainly appropriate.
And Your Honor, to clarify for the record, the 2018 battery family violence charge did result in a guilty conviction. That case number is 18SC 163749. So that is a guilty conviction.
All right, this instance is just a matter of exchanging words. It's not exactly, sorry. It's not a violent incident.
You said it's not a violent incident?
No, it's just an argument, and according to the incident report, he threatened to burn the place down, but there was no present ability or intention to do so. It was an argument between roommates.
And Your Honor, I would argue that the defense can't state whether the defendant had the intent or the ability to do so. He threatened these victims, and that's why we are here today.
I'm not sure if I would characterize it so much as it's not violent. It could have been, and I understand these are mere allegations. I'm going to go ahead and order the $5,000 surety bond, $2,500 on each of the charges, because that is serious when you're alleged to have threatened someone in that manner. I'm going to order a stay away from 179 Haygood Avenue Southeast, even though he doesn't live there, it just shouldn't go over there anyway. And no further contact with the two witnesses, I'm sorry, the two victims with the last name G-A-N-A-H-L, Ganal, and also no further contact with the witnesses. I don't think, Miss Sorry, did you tell me there were two witnesses as well?
Yes, I did, Your Honor. First is Daryl Williams. Second is Andrew Burke.
Okay. All right, so there'll be no further contact with them as well. No drugs, alcohol, or weapons while on bond.
Your Honor.
You need to defer to your attorney.
Yeah, Mr. Dominello, don't say anything right now.
All right, that will conclude this case.
Thank you, Your Honor.
Thank you.
All right, this is one number 3, Mr. De La Rosa.
All right, Madam Interpreter, can you raise your right hand for me?
Yes, Your Honor.
Yes, do you solemnly affirm that you will faithfully interpret from, and I didn't ask you the language, is it Spanish or something else?
It is Spanish, Your Honor.
Okay, that you will faithfully interpret from English to Spanish and Spanish to English, the proceedings before the court in an accurate manner and to the best of your skill and knowledge with no embellishments?
I do, Your Honor.
All right, thank you. And this is which position again? I'm sorry, Deputy.
Number 3, right?
3. Yes,
Yes, number 3.
thank you. This is case number 22 CR 004749. Mr. De La Rosa, you're charged with 1 count of criminal trespass and damage to property with the offense date of July 24th, 2021.
Este es el caso número 22 CR 004749. Es un cargo de traspaso criminal y daño a propiedad con la fecha de que esto ocurrió el 24 de julio del 2021.
All right, pretrial, do you have anything?
Second arrest. Last arrest was 2012, driving without a valid license conviction. That's it.
Okay,
Las personas antes de llegar a juicio le preguntan si es que tiene antecedentes e indican que este es su segundo arresto, que el arresto anterior sucedió en el 2012 y eso fue por no tener licencia de conducir.
all right, Ms. Sorry.
Yes, Your Honor. In this case, officers responded to 201 Northwood Drive in Atlanta. The victim in this case, her name is Diana Cruz, and she stated during a verbal argument over the internet not working at home, the defendant got upset. He took her cell phone and threw it on the ground, causing it to break. Our office did reach out to the victim, and we were not able to get in contact with her. The state is amenable to a $1,500 signature bond. We will defer to the court regarding whether it's through pretrial or the jail. With conditions of a one-day anger awareness course, stay away, no contact with the victim, as we were not able to reach her and find out her feelings on contact, and no drugs, alcohol, or weapons.
All right, Mr. Silverman.
Your Honor.
Oh, I'm sorry, Ms. Kim.
No, actually, if you would allow me to interpret.
Oh, I'm sorry. I apologize. Go ahead. Do you need her to repeat it or?
No, that's
Okay.
fine. I took note.
Okay.
Y la fiscalía, el caso que ellos presentan, lo que dicen ahora es que el día de que esto sucedió, la policía fue llamada al 201 Northwood Drive en Atlanta y que fue entrevistada la señora Diana Cruz, quien indicó que tuvieron un altercado y un argumento verbal porque no estaba funcionando internet en la casa y que usted entonces tomó el teléfono de ella y lo tiró y se rompió. Lo que la fiscalía está sugiriendo es un bond, una fianza de $1,500, ya sea con cierto caso antes del juicio o con servir en la cárcel. También sugieren un curso de un día de cómo controlar las iras y también una orden de que permanezca lejos de la residencia, ya que no han podido ellos encontrar a la víctima, a la señora, para preguntarle si es que ella está dispuesta a que usted regrese o no. Eso es lo que ha puesto la fiscalía, como ha presentado el caso a ellos. Ahora le toca a la defensa. Go ahead, Mr. Silverman.
Thank you, Your Honor. Mr. De La Rosa is 30 years old. He's lived in the Atlanta area for 15 years. He works as a temporary worker, contract worker in the construction business. He works frequently and he works hard to support his family, which consists of 3 young children and Diana Cruz, the alleged victim in this case. This incident happened over, 2 days short of a year ago. And this was a completely verbal argument between spouses. And the only allegation here is that Mr. De La Rosa got angry and threw a phone. I'll let Madam Interpreter, you want to catch up?
Su señoría, el señor de la Rosa tiene 30 años de edad, ha vivido en el área de Atlanta por los últimos 15 años. Él trabaja en construcción la mayor parte del tiempo y para poder mantener a su familia, que consiste de 3 hijas menores de edad, con la señora Diana Cruz, incluyéndola a ella. Este es un incidente que sucedió hace un año atrás, fue un argumento verbal entre marido y mujer, básicamente, y lo que se está alegando, pues, es que es nada más lo que se está alegando.
Mr. De La Rosa tells me that the parties are still living together, the children are still there. For the most part, everybody's happy, and he does not believe that Ms. Cruz wants to pursue this matter. Now, I'm not sure why the state has had such trouble getting in touch with her because they still live together at the incident address. Mr. De La Rosa, his only other offense since he came to Georgia 15 years ago is driving without a license. He has no history of other criminal offenses, no drugs, no violence, no domestic violence. Again, I'll stress that this is just over a phone, and he did not throw it at her, which is certainly worthy of mentioning. Pretrial has recommended him for an unsecured judicial release, and I believe that is most appropriate with no further conditions, and certainly not a stay-away order. He's working and he supports his family, and that's where he lives. That's all I have. Thank you.
And I'm sorry, Your Honor, if we weren't able to reach the victim because we don't go out to their homes, we do reach out via phone. So if the defense counsel says,
I'm so sorry to interrupt. I'm sorry. Would you allow the interpreter, please?
Oh, I'm sorry.
To interpret what Mr. Silverman just finished. El señor de la Rosa me dice que han estado viviendo juntos en la misma casa, que él no cree o que usted no cree que la señora va a perseguir esta demanda y que viven juntos y han vivido juntos sin mayor incidente. No ha tenido ningún historial criminal ni de delitos, aparte de lo que es ese arresto de manejar sin licencia de conducir. No hay ningún historial de drogas, no hay ningún historial de violencia y y también cabe la pena mencionar que no le tiró el teléfono a ella. Entonces, que no estaría de acuerdo con que se mantenga lejos de la residencia, ya que usted vive en esa residencia y usted trabaja. Eso fue lo que él dijo. Entonces, ahora es el turno de la fiscalía otra vez. I'm sorry, Miss Sorry. Go ahead, please. I apologize for interrupting.
No problem, and I apologize. As I've stated, we do not go out to homes of victims. We contact them via phone. So if the defense attorney would like to put in the chat this victim's phone number, we can contact her regarding this case.
I don't have any further information other than what's already in the paperwork.
La fiscalía indica que ellos no salen, no van porque ellos dicen que no han encontrado a la víctima, la señora, pero lo que la fiscalía indica es que ellos no van a las casas de las víctimas a buscarlos, ellos les hablan por teléfono y tal vez si es que el abogado de la defensa tiene el teléfono les puede pasar eso, pero indicó el señor Silverman que no, que él no tiene acceso al teléfono de ella aparte de lo que está en los papeles.
Mr. De La Rosa, does Diana have her own phone?
Señor de la Rosa, ¿tiene Diana el teléfono de ella propio? O sea, ¿tiene una línea de ella
No tengo ni teléfono yo aquí ahorita. So, no tengo yo la manera de contactarla yo a ella.
I don't have a phone on me. I don't have a way to reach her or contact her.
No, does she have a phone number?
La pregunta fue si es que ella tiene teléfono, que usted sepa, ¿tiene el número de teléfono de ella?
No, ahorita no tengo el teléfono de ella aquí, pero o sea, sí, yo sé que sí tiene teléfono, no lo tengo.
I know she has a phone. I don't know the number. I don't have it on me.
That's fine. The state is, again, amenable to a signature bond on this case.
All right, thank you.
Okay. All right, then I will grant the $1,500 signature bond through the jail. The 1-day anger awareness course. No drugs, alcohol, or weapons while on bond. And I'm still a little torn. No further contact with the victim, since we've not heard from her. I don't know if the parties have been residing together. I know this did happen in 2021.
La juez está dando un bono de una fianza de $1,500. Le va a dejar salir solamente con su firma el día de hoy, le tiene que tomar un curso de un día de cómo manejar la ira y no puede, durante el tiempo que está en fianza, antes de regresar a la corte, no puede tener ni nada de drogas, ni alcohol, ni armas. En cuanto al contacto con la víctima, ya que no se ha tenido contacto con la víctima, esto ocurrió hace un año. ¿Han estado viviendo juntos después de eso?
Sí.
Yes.
Can you ask him, are they still residing together?
¿Han estado viviendo juntos?
Sí.
Yes, Your Honor.
And I'm going to assume there's been no incidents since 2021. So I will say no further violent contact with Diana Cruz.
Y asumo que no ha habido ningún otro problema después del 2021. Si es que es así, la juez lo que ella dice es que le ordena no contacto violento con Diana Cruz.
And I think I already said no drugs, alcohol, and weapons, correct?
Y
Correct.
también le dije no drogas, no alcohol, no armas.
One day anger awareness course.
Un día, una clase de un día para un curso de cómo manejar la ira.
And I think that resolves everything. Anything else, Mr. Silverman or Ms. Sorry?
No, Your Honor, thank you.
Nothing further from the state.
Y
Okay.
esto resuelve todo. Así que eso es todo lo que es la orden de la juez.
Pero sí puedo llegar a mi casa, ¿verdad? Porque pues no tengo otro lugar donde ir.
But I'm able to go home, right? Because I don't have anywhere else to go.
Right, yes, this is a signature bond for 1,500, but I'm basing it on the fact that there hasn't been any other violence, but there's no further violent contact. And he can go home as long as there's no violence. And he has to take that one-day course.
Y sí, le está dejando ir a casa, pero no puede haber ninguna violencia doméstica y tiene que tomar ese curso de un día.
Your Honor, I think you implemented a signature bond through the jail.
Yes, I'm sorry, signature bond through the jail. Did I say
1,500.
that? Yes, Mr. Toussaint?
All right, that's all I was just making sure.
Yes, it was signature bond through the jail.
Okay.
All right. That should conclude this case.
All right, that's bill number 6, Mr. Garcia Reyes.
This is case number 22 CR 0047691. Mr. Garcia Reyes, you're charged with 1 count of DUI, driving under the influence of alcohol as safe, and a 2nd count of driving improper, erratic lane change, both with the offense date of July 21st, 2022.
Este es el caso número 22 CR 0047691. El primer cargo es una acusación de manejar bajo la influencia del alcohol, o en inglés un DUI. Y la segunda acusación, el segundo cargo es que estaba manejando erráticamente y de forma no apropiada.
All right, Ms. Falk? I'm
Yes,
sorry, pretrial.
Oh.
I'm sorry, pretrial.
This is 4th arrest.
4th, okay.
All right, last arrest was 2019 DUI. I don't see I didn't look the disposition of state, probably knows it.
I could not locate a disposition.
Yeah, it was out of Johns Creek. 2010 driving without a valid license conviction, and a 2006 hit and run that was dismissed from North Carolina. And he's a resident of Chicago. That's it.
All right.
La información de antecedentes de antes del juicio es que este es su 4º arresto. El arresto anterior fue en el 2019, también por manejar bajo la influencia de alcohol. En el 2010, por manejar sin una licencia de conducir. Y en el 2006, en Norte Carolina, porque golpeó y se fugó. Y también es importante saber que usted es un residente de... can you repeat a resident of? I apologize.
Chicago.
De Chicago. Thank you.
Your Honor, this incident happened at 1:44 a.m. Well, I believe it actually would have been this morning at 1:44 a.m. on State Bridge Road.
Su señoría, esto sucedió a la 1:44 de la mañana de este día en State Bridge Road.
The defendant was observed drifting from left to right in one lane on State Bridge Road, and then was observed crossing over the double yellow line into the opposite lane of travel when he executed a left turn.
El acusado fue observado cruzando y moviéndose de la izquierda hacia la derecha sobre la State Bridge Road y después cruzarse sobre las dos líneas, la doble línea amarilla para hacer una vuelta a la izquierda.
Officers at that point made a stop and approached and made contact with the defendant.
Los agentes en ese momento lo pararon al acusado y intentaron hablar con él.
They observed that the defendant had bloodshot eyes and an odor of alcohol coming from his breath.
Observaron que el acusado tenía los ojos rojos y había un aliento de olor de alcohol que salía del acusado.
The defendant denied any kind of traffic violations, but when questioned, he did admit to having several Bud Light beers earlier that evening.
El acusado negó haber hecho algo malo de tráfico, pero admitió haber tomado varias cervezas esa noche.
Field sobriety testing was then conducted on the defendant.
De ahí le hicieron una prueba de alcohol en el campo, ahí en la calle.
The defendant showed 6 clues on the HGN, which, as Your Honor knows, is the most reliable portion of the field sobriety testing, indicating alcohol intoxication.
Y el acusado salió positivo en 6 partes de la prueba Xgen, que es una de las pruebas mejores para esto, lo cual indicaba que el acusado estaba intoxicado con alcohol.
The defendant also showed 4 clues on the walk and turn and 3 clues on the one leg stand.
También enseñó 4 defectos entre si es que se paraba mientras caminaba y 3 mientras se paraba en su propio lugar.
The defendant was unable to provide a breath test for the preliminary breath test, and when he was read implied consent, he refused a blood test.
Y el acusado también no dio su aliento para una prueba de sobriedad y también se negó a una prueba de sangre.
As pretrial has pointed out, the defendant does have an open 2019 case for DUI out of municipal court.
Como lo han dicho ya, el acusado tiene un caso ya de un DUI que no ha sido solucionado todavía del 2019 en corte municipal.
And a 2011 conviction for driving without a license.
Y en el 2011 una acusación y un cargo de manejar sin licencia de conducir.
Our concerns here is that this is the second DUI arrest this defendant has had in less than 5 years.
Nuestra preocupación es que este es el segundo cargo de manejar bajo la influencia del alcohol o DUI en los últimos 5 años.
Which indicates this defendant has a risk of reoffending for this particular type of crime.
Lo cual indica que este acusado tiene un alto riesgo de volver a ofender con la misma ofensa nuevamente.
We are also concerned that this defendant is not a resident of the state and is in fact a resident of Chicago, Illinois.
Y también tenemos preocupación que este acusado no es un residente en este estado, es un residente en Chicago, Illinois.
which shows the defendant has insufficient ties with our community.
Lo cual indica que el acusado no tiene suficientes lazos con nuestra comunidad.
To that end, the state is requesting a $5,500 surety bond.
Por eso el Estado está pidiendo una fianza, un bond de $5,500.
The breakdown is $5,000 surety bond on the DUI and a $500 surety bond on the improper lane change.
Y eso es $5,000 por el DUI y $500 por el cargo de haberse cambiado de carril inapropiadamente.
We are further requesting that the defendant not be permitted to drive unless it's to work, home, the doctor, or his attorney.
Estamos pidiendo que el acusado no pueda manejar, no tenga permiso para manejar, aparte de y únicamente para ir y venir de su trabajo, para ir y venir de un doctor o para ir y venir de su abogado.
And no alcohol, drugs, and weapons. That is all for the state.
Y no consumo de drogas, alcohol o tener armas. Y eso es todo lo que sugiere la fiscalía.
Yes,
All right, Ms. Kim.
yes, Mr. Garcia Reyes is, actually, he will be 44 next Friday.
Sí, el señor García Reyes va a cumplir 44 años de edad el próximo viernes.
And even though he has Illinois license, he has been here in Georgia for 19 years.
Y aunque tiene una licencia de conducir del estado de Illinois, ha estado aquí en el área de Atlanta por los últimos 19 años.
He has a 14 years old child.
Tiene una hija, un hijo de 14 años de edad.
Co-parenting with her mother, and he has cousins here in Georgia.
El cual él también es o sea, es padre de esa criatura y con la mamá, y también tiene primos aquí en el estado de Georgia.
And he has been gainfully employed at OYOC's landscaping company for last 2 years.
Él ha estado trabajando para Oasis Landscaping por los últimos 2 años.
And he has 9th grade high school education from Mexico.
Tiene una educación desde el 9º grado de la escuela desde México.
So he has a ties to the community.
Entonces tiene lazos en la comunidad.
And we would like to request for signature on bond. And yet, if your honor is not inclined to give him a signature on bond,
y lo que queremos nosotros pedir es un bono, una fianza solamente con la firma, pero si es que usted, su señoría, no quiere hacer eso, entonces
we would like to request for maximum $2,000 DUI surety bond and $500 signature on bond through jail for improper lane traffic ticket.
Y entonces nosotros quisiéramos sugerir un bono de fianza de $2,500 por el manejar bajo la influencia de alcohol y $500 con firma para la ofensa de cambiar inapropiadamente de carril.
That's it, Your Honor. Thank you.
Your Honor, you're on mute.
Yes, I'm
Your
sorry.
Honor, the state would just like to point out one thing. Obviously, under OCGA 40-5-20, this defendant has 30 days to, if he is in the state of Georgia, has 30 days to get a license from Georgia. He seems to have overshot that by 18 years and 11 months.
También quiero indicar que si el acusado en realidad vive aquí, él tiene normalmente 30 días para obtener una licencia de conducir del estado de Georgia, entonces parece que se ha atrasado con más de 18 años.
All right. I'm going to go ahead and rule that there's nothing else from either side.
Si no hay nada más de ninguno de los dos lados, la juez va a emitir la orden.
I'm going to order the $5,500 surety bond with the $5,000 on the DUI and 500 on the improper lane change. I'm going to order that there be no driving because he obviously does not have a driver's license. He can only go to seek medical care, or to the court or to see his attorney. There's a lot of other ways to get around these days. And I would say to go to work, but I don't want him doing those limited driving privileges, I guess. He'll have to keep the order with him or get that. They can get it from DDS, I believe. Yes, okay.
Yes, Your Honor.
Right, so it'll be those limited privileges to go to work, doctor or court or to see his attorney. Otherwise, he should not be driving and taking Uber, bus, or some other form of transportation. No drugs, alcohol, or weapons while on bond except for anything prescribed to him. And I think that's all I was going to order at this time.
La orden de la juez entonces es que va a pagar la fianza. El bond es de $5,500.
Okay.
$5,000 por el DUI y $500 por el cambio inapropiado de carriles. Aparte de eso, le ordena el no manejar. Solamente puede, con la excepción de manejar al doctor y manejar a la corte o a la oficina de su abogado. Ni siquiera puede manejar a su trabajo. Necesita mantener esta orden que le van a dar este papel con usted siempre, porque si lo detienen y no está manejando a uno de esos lugares, entonces se lo pueden llevar. Eso, y no puede tener durante el tiempo que está en la fianza, no puede consumir drogas, no puede consumir alcohol y no puede tampoco tener ningún arma.
Okay, está bien.
Okay, that's fine, thank you.
All right, that concludes this case.
Okay, eso es todo para este caso. Thank you, Your Honor, and I believe that concludes my business with the court. May I be excused?
Yes, you may. Thank you for your services today.
Thank you, Your Honor. Have a good weekend.
You too.
Your Honor, that's all we have in quorum too. May we be excused?
All right.
All
Have a
right.
good weekend.
All right, you too, Your Honor.
Thank you. Ms. Grace, do we have anything else? I think
That's it, Judge.
all right, we're ready when you are.
Okay, position number 1 is $1,000 good bond. Position number 2 is a $5,000 good bond. Position number 3 is a $1,500 SOB through jail. Position number 4 is a $5,000 good bond. Position number 5 is a $2,000 split bond. Fair evasion is $500 SOB through jail. Willful obstruction is a $1,000 good bond. And the third willful obstruction is a $500 SOB through the jail. Position number 6 is a $5,500 good bond. Position number 7 is a $3,000 good bond. Position number 8 is a $1,500 good bond. Position number 9 and 10 is a $7,500 cash bond only for both cases. Position number 11 is a $2,500 good bond. Position number 12 is a SOB through the jail. Any concerns or questions?
Nope, that's what I have. Anyone else? All
Your
right.
Honor,
I'm sorry.
On number 5, Mr. Ferguson, he has a hold in DeKalb, and I'm not familiar with sure how this process works, but
When he bond out, he'll go to DeKalb.
okay.
Judge made that a part of her orders that he be released only to DeKalb County.
All right,
Correct.
thank you.
Yeah.
Thank you.
That is correct. All right, thank you, everyone. I will see you next time. Have a good weekend.
Thank you, Judge. I'll be sending these over to you.
Yes, ma'am. Thank
Bye.
you. All right, bye-bye.
Hello?